Is the illegal migration bill illegal? Let me explore the 6 controversial measures in the bill which might make it illegal according to international law. The illegal migration bill aims to meet the challenge head-on to stop small boats crossing the Channel, mainly from France, which are filled with people seeking refuge and a better life in the UK. To give some context to the new bill, the government have set out the current problems and challenges. In 2022 alone, over 45,000 people have made the perilous journey crossing the Channel in small boats, exploited by criminal gangs. The number incidentally compares with over 100,000 people who came to the UK via a safe route from Ukraine in 2022. The government claims that many people who cross the Channel are not genuine asylum seekers, especially those from Albania. It costs £6 million per day to accommodate people once they arrive in the UK. That's £3 billion per year, according to government figures. And the numbers involved are overwhelming the asylum system and increasing the backlog to deal with existing asylum claims. The bill is not the first direct legal attempt to stop the small boats. In fact, the government's first legal attempt to stop the small boats crossing the Channel was the Nationality and Borders Act 2022, which made the similar promises which lie behind this new bill to save lives and break the economic model of people smugglers. That 2022 Act introduced a 2-tier system of refugee protection. Group 1, refugees who travelled to the UK directly from a country where their life or freedom was at threat. And Group 2, refugees who travelled to the UK through third countries, e.g. France, via irregular routes like crossing the Channel in small boats. Criminal offences were also created for those in Category 2, together with a greater government focus to tackle the criminal gangs. Now, missing from this previous legal and political strategy was any real progress with France to stop crossings in the first place, the lack of immigration personnel to process the asylum claims, the lack of judges to hear asylum claims, and the lack of lawyers to provide legal advice, and not forgetting providing more safe routes other than the select 3 we have at the moment to claim asylum in the UK, which would likely significantly reduce small boat crossings. All of such measures would speed up the decision-making process of whether a person should be granted refugee status or not, be cost-effective and deter people crossing the Channel. But what do I know? Following shortly after the 2022 Act was the much-heralded Rwanda policy, a one-way ticket for anyone in Group 2 who entered the UK illegally and who would be removed and have their asylum claim processed in that African state. No one has been sent to Rwanda to date due to various legal challenges, such as the European Court of Human Rights in Strasbourg granting a Rule 39 interim measure, in effect an injunction to stop a plane boarded and bound for Rwanda. A High Court confirming the Rwanda policy was lawful, and the ongoing appeal to the Court of Appeal whether the Rwanda policy is lawful and not in breach of UK obligations under the European Convention on Human Rights. What the government also believes is that the projected numbers crossing the Channel will be the same, if not more, this year and in years to come if nothing is done. And that will present more challenges, including possibly the increased local concerns with asylum seekers living in particular areas. Hence, the illegal migration bill has been introduced as part of the UK government's 5 key priorities. Number 5 on the list is small boats, passing new laws to stop small boats. While the illegal migration bill is the government's renewed attempt to stop small boats, it is controversial. And so here's 6 controversial measures contained in the illegal migration bill which might make it illegal according to international law. The first controversial measure in the bill are many measures might not be human rights compliant. It's normal that any bill that is put before Parliament makes a statement that the measures contained in it are compliant with and respect human rights. However, the government does not make this claim in this bill. In the bill, it says this: Secretary Suella Braverman has made the following statement under Section 19(1)(b) of the Human Rights Act 1998. I am unable to make a statement that, in my view, the provisions of the Illegal Migration Bill are compatible with the Convention rights, but the government nevertheless wishes the House to proceed with the bill. So the following rights are therefore at risk of being denied to people entering the UK illegally, so-called, should the bill's measures become law. Article 3, freedom from torture and inhuman or degrading treatment. Article 5, right to liberty. And Article 8, right to respect private and family life, are just a few of the rights at risk of being breached. The second controversial measure in the bill is the increased powers given to just one person, the Home Secretary, to remove people, including children, who have entered the UK illegally if they meet the 4 conditions contained in Clause 2. This would also include potential genuine asylum seekers because they illegally entered the UK on a small boat. According to the explanatory notes to the bill, this clause places a duty on the Secretary of State to make arrangements to remove to their home country or a safe third country those who have entered or arrived in the UK illegally and the conditions under which this duty will apply. The duty to make arrangements for removal is absolute, subject to subsequent provisions in the bill as specified in subsections. There are 2 groups who the Home Secretary may not remove. Unaccompanied children, Clause 3, which provides that the duty in Clause 2.1 does not require the Secretary of State to make removal arrangements for unaccompanied children until they turn 18 years old, although she may do so whilst they are under 18 using the power in 3.2, and for the Secretary of State to specify other exceptions in regulations as per the explanatory notes, and potential victims of modern slavery, Clause 21, which makes provisions for the duty to be suspended where a person is a potential victim of modern slavery and is cooperating with law enforcement agencies in connection with the investigation or prosecution of an offence relating to them being a potential victim of slavery or human trafficking. The third controversial measure in the bill is excluding courts, including judicial review and appeals, to challenge the Home Secretary's decisions to remove a person. This is achieved by denying the person being able to make a claim. Any removal would be a breach of their human rights and or the person's claim they were the victim of human trafficking contained in Clause 4. This clause provides that the duty in Clause 2.1 to make arrangements to remove or the power to make arrangements in Section 3.2 applies to persons that meet the conditions under Clause 2, regardless of whether they have made a protection claim or human rights claim, they claim to be a victim of slavery or human trafficking, or have made an application for judicial review in relation to their removal from the UK under the bill, as per the explanatory notes. The fourth controversial measure in the bill is the Home Secretary's power to remove a person to a safe third country, or so-called safe third country, contained in Clause 5. The explanatory notes state a person may be removed to a country or territory where they have nationality or citizenship, have a passport or other identity document for, where they embarked for the UK from, or where they will be admitted, i.e. Rwanda. There is an exception for a person to apply to the court to suspend removal to a third country. A person will not be relocated to an otherwise safe country, such as Rwanda, if they make a human rights-based claim and the Home Office concludes in respect of that claim that there is a real risk of serious and irreversible harm were that person to be so removed, as per the explanatory notes. Fifth controversial measure in the bill are related to detaining a person once they illegally arrive in the UK, contained in Clause 13. Clause 13 removes the right of the Immigration Tribunal to grant bail until after the end of the period of 28 days. The sixth controversial measure in the bill is a lifelong ban on a person to be eligible for citizenship, including children, because they enter the UK illegally, contained in Clause 30. Subsection 3 provides that a person will not be eligible for citizenship if they have ever met the 4 conditions contained in Clause 1 of the bill. There are limited exceptions to gaining citizenship, but not many. With these controversies, will the bill have a rough ride in Parliament? Very likely. Should the bill be passed into law, it is also likely to face months, if not years, of legal challenges, all the way up to the European Court of Human Rights in Strasbourg, who may very well declare certain measures in the bill to be a breach of the European Convention on Human Rights and other treaties, and thus illegal contrary to international law. And assuming the law is passed, and assuming the European Court rules in favour of the government that the measures are legal, will the measures work to stop the small boats? Well, it depends whether people will be deterred from taking the journey to cross the channel knowing what awaits, and whether there are sufficient safe third countries to take in thousands of people every year. Welcome to the UK. Feel free to comment, follow, like and share.